Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about deliberation delays. Cases that should have gone to the Supreme Court of Canada, but didn't. In a case coming out of Quebec, there was an individual who argued that his right to be tried within a reasonable time was violated on the basis of the fact that the judge took an additional amount of time during the trial to make decisions on interlocutory issues, charter application, various issues that arose in the course of the trial. And each time one of these decisions had to be made, that prolonged the process, meaning the case couldn't complete. He argued that that time, in between when he made these arguments to when the final verdict was rendered, violated his right to be tried again in a reasonable time because it prolonged the case past the 18-month ceiling. The Quebec Court of Appeal disagreed, and he sought leave to the Supreme Court of Canada, which denied the leave. And it's actually very surprising the Supreme Court of Canada didn't agree to hear this case, because there are inconsistent judgments from different appellate courts across the country on this issue. In Ontario, the law has said that interlocutory time for deliberation of a judge in applications that happen mid-trial, is something that counts towards the 18-month ceiling. That when setting trials, we anticipate there are going to be mid-trial applications that need to be decided. Often trials are scheduled in different blocks for the time for these applications to be heard. And so if a judge takes longer than is scheduled or expected to render those decisions, or if an issue arises because of something surprising in the trial, that's not delay that should weigh against the defense. That's the problem of the Crown for not properly interviewing its witnesses and anticipating issues, or a problem of a judge falling into that culture of complacency that all parties in our justice system are guilty of, including the judiciary. This is something that the Supreme Court of Canada ought to have decided on, because it has, since Jordan, decided on other issues surrounding delay. The Cody case, where it's decided on how to deal with these interim cases that were before Jordan and resolved after Jordan. Cases involving youth criminal justice prosecutions and whether the 18-month ceiling should also apply to those. These are all the same things that the Supreme Court of Canada has already heard on in terms of issues that affect Jordan that don't have consistent answers across the country. And it would have been important for the Supreme Court of Canada to chime in here, not only to resolve conflicting judgments in the appellate authorities, but also to ensure that when we're considering the culture of complacency, trial scheduling, and the need for timely decisions in mid-trial applications, that this is something to keep the courts and the system accountable as much as it is to keep the parties accountable in any proceeding. Unfortunately, we'll take another case with another argument about unreasonable delay, not like those are hard to find, for the Supreme Court of Canada to agree to hear this issue. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Please like, subscribe, and share with your friends.